All right. Well, welcome to another episode of Ask Two Lawyers. I'm Keith Davidson,
Hello, I'm Stewart Albertson.
and we really appreciate you joining us today. Stuart, we've gotten a lot of really great feedback just in terms of our videos and what we've been doing, and people really enjoying, I think, the information that we bring. We did the Vanderpump Rules cases. You and I know almost nothing about the show, and so we brought in our paralegal Christy to help us out there. But we had a lot of fun talking about the legalities of it and kind of sharing that. If you want more information on us, you can always look at our YouTube channel for Albertson and Davidson. We have tons of videos there on what we do, which is trust and will litigation, and then of course our website. So today we want to get started with a little bit of a Tom Girardi update. There's not a ton going on, but there was an interesting article that came out from Amanda Bronstad, who we interviewed on our podcast. What was that, a couple weeks ago, Stuart?
It was, yeah.
And apparently the attorneys in Illinois, where with the Lion Air case, are saying that they may be dropping charges against Tom Girardi, criminal charges against Tom Girardi. But they want to wait and see what happens with the sentencing on December 6th and wait until judgment is entered against him. So I thought that was kind of an interesting development. Let's see here. Girardi, as we know, faces a maximum of 80 years in prison on the California charges that he was convicted on. Everybody's saying he probably will get less than that, but it really doesn't matter. He's 85 years old. Even a 10-year sentence is a life sentence. I'm assuming that's why the prosecutors in Illinois would be interested in dropping charges. They figure if he gets 15 years, 20 years, 25 years, he's in for life. There's nothing, they can't put him in jail more than already being in jail. So what's the point? Why waste the resources? But I don't know if you had any thoughts on that, Stuart.
I mean, not really, other than what you just said, and that is, I think they're playing a chess game here, and they're realizing that they're hitting the mark without having to do all of the extra efforts with limited resources, so they can just focus in on the civil matters and not have to worry about the criminal standard and all of that.
And dropping Girardi is not going to change the fact that the CFO, Christopher Kamen, well, we are calling him Kamen. A lot of people called him, I forget how they pronounced it, Kamon. He's still going to be prosecuted criminally. So he's still going to be going to trial here in California in January. And there's no talk about dropping charges against him in the Lion Air crash or, any of the other criminal charges that he has pending against him. So this would only be for Girardi. And that kind of makes some sense. So we'll see what happens. December 6th is going to be the sentencing on Tom Girardi, and we'll be able to have more of a discussion once that happens. Okay, so let's talk a little bit about, we put out a video about Robbie Robertson, and somebody, one of the founders of the band, Stewart, is that who he was?
That's right. He was a lead guitarist and founder of the band and an incredibly talented musician and businessman. I don't think people knew exactly how talented he was until the end of his life. His life is over, and we got this fantastic article written. I think it was at the Rolling Stone magazine or one of the some magazine did a great article. I mean, I didn't realize how talented the guy was, but he was an extremely talented individual that passed away. Obviously, he just remarried to a new wife, and he had 3 children from a previous marriage, all in their 50s and higher, and not too much younger, quite frankly, than the new wife. And of course, there's going to be claims and allegations of undue influence, lack of capacity, financial elder abuse against the wife, because she ends up getting a pretty much a sweetheart deal in the estate. And there's nothing wrong with her getting a sweetheart deal if that's truly what Robbie Robertson wanted and intended. But the kids are saying that's not what he intended. So they want their day in court to have a determination of, should these assets go pretty much to the wife for her lifetime? And it'll be very expensive during her lifetime. She's still relatively young. Or was there some type of undue influence that would negate those gifts to the wife? And then, of course, those assets would flow through to the children.
Yeah, and it's a classic case of the children versus new wife, right? And so you have the new wife come in, and she has her own view of what the situation is. And the children from the prior marriage, they have their own view of what the situation is. And so we run out across these cases constantly where you have these family dynamics where people are fighting. over the estate. And of course, each side thinks that they're 100% correct. Neither side really thinks that they're being greedy, and each side accuses the other of being greedy.
Yes.
But in this case, so you have, like, for example, the wife, she comes along and her view of the world, it seems to be, and I don't, we don't represent her. We've never talked to her, but just based on the pleadings and what we've seen is that she was going to be taken care of. So she was here. She was, his life partner. They were married at some point. And her thought was, well, at least I'll be taken care of because I'll have the house, and then all the expenses of the house will be paid for. And just as a general proposition, that sounds like a fair and nice thing to do for somebody who is your life partner, I suppose. The problem in this case, of course, is that the upkeep on the house is supposedly, based on what we've read, is going to bankrupt the rest of the estate. And you can't use the money from the house to pay for the maintenance on the house, because the wife's entitled to the house plus maintenance on the house and upkeep. So you have an asset in the house that might be worth 5-6 million, whatever it's worth, but you can't sell it and use that money to pay to the wife, because she's entitled to continue living there. She has a life estate. You can't just take that away from somebody. And so you could see where somebody in her position would say, well, this is what my husband wanted for me, and so this is what I should be getting. And if you were to change positions and think about what the kids are looking at, now they're looking at this saying, wait a minute, I'm going to end up with nothing, because by the time we pay for this upkeep and maintenance on the house for the lifetime of the spouse, and she's in her late 50s, she could be alive for a long time. It's all going to be gone. So what's the point? This couldn't possibly have been what my father wanted, because he wanted us, to receive something. And so how do we end up in situations like this? It seems like bad planning in large part, but I don't know.
Well, if you take the kid's perspective of it, you can understand it. And also if you take the wife's perspective, you can understand aspects of that as well. But the kids, in this case, had a good relationship with their father from the reporting. This is not a case where the kids, didn't hang out with dad or, try to renew a relationship at the last minute so that they could be included in the estate. This was the kids that had a good relationship. There's family photos of them traveling together, enjoying their time together. And then there's this, interloper that comes in the kid's mind of this person that, hasn't had the rich history and experience that they've had with their father. And, they do go to some estate planning, but the question is, did he really know what he was doing? And that's a question that has to be determined. If he knew what he was doing, then fine. Then he's entitled to do whatever he wants with his assets. By the way, he could even have a good relationship with his kids and choose not to give anything to them. That's his choice. But we, under California law, want to make sure that this is really what his choice was. And the kids are saying, that's not what he wanted. He told us that everything was his and everything was hers, and that everything that was his would be going to us. When I should restate that. He told his kids multiple times, I own what I own. She owns what she owns. And of course, you guys are going to get what I own. But that's not how it turned out. And of course, he's not here. He's gone now. So we can't ask him to help us out. So we are left with going to court, putting our positions forward, the kids putting their position forward, the wife putting her position forward. And good lawyering is going to happen in this case. There'll be good lawyers on both sides because it's a sizable estate. It's also the publicity of the estate. So you're going to get good lawyering. And we're going to see basically just about everything that happens in California trust contests is happening in this case. And we'll see it as it plays out in the court system.
Yeah, the thing that I didn't understand either, I now remember, is it was a Hollywood Reporter article that we read, and that really laid out the entire case, like from kind of beginning to end. Then we looked at some of the pleadings, but in that article, it talked about how Robbie Robertson had sold his music catalog for $25 million. And so you're thinking, well, that's a substantial amount of money. Where did that go? But what it didn't say is what the terms of that sale were. So was it, a lot of times it's not just cash up front. They might, maybe there's a certain amount of money up front, which might have been used to buy the house. And then there's money over time paid on that as the royalties come in on the catalog. So it'd be interesting to know what the structure of that deal was, because if you just had 25 million cash, then maybe the children aren't happy with the situation, but it's not enough to sue over because it won't bankrupt them. They have other money. But if that's all you have is the house, and now you're looking at having to pay, 5, 6, 7 million on top of that over the next 20, 25 years to maintain the house for somebody who you clearly don't care for to begin with, that's where lawsuits come from. And I think part of this is just not really thinking about it. It sounds nice to, for somebody to say, I want you to have the house and I want to make sure that you're taken care of and that all the expenses of the house are paid for. I mean, that's a nice concept, but it's not practical. Somebody didn't sit down and tell this guy, wait a minute, how are you going to even do this? How are you going to fund it? What money is it going to come from? What happens if there's a huge expense on the house, like a new roof? Are you expecting the kids to pay for that? Does the wife pay for that? And supposedly the wife in this case, has a lot of money in her own right, so she says. So, what was the thought process behind that when they tried to even do, this plan as it was? And I think that we see a lot of that. We see a lot of people planning things that, quite frankly, they didn't really sit down and think it through. And so I want to do X or I want to do Y. I want to leave my house to my kids, but I want my new spouse to be able to live there. Well, you really have to map that out. And, maybe because we're litigators, we see the worst of the worst. And so we always think in worst case scenarios. But a lot of times we see these plans and it's just like, what were they thinking? And it just doesn't seem like this was an integrated plan where somebody sat down and thought about, how are we going to do this?
Well, and then you add in how old this guy was in his 80s. So the question is, what was his understanding of the plan, even if you could explain it to him? It may have been a perfect understanding, but in many cases, it is not a perfect understanding. And you have somebody helping them along. And then usually that person is the one that ends up getting the windfall. So, and lawyers have to be careful with this. There's good lawyers, good estate planning lawyers out there. And then there's questionable estate planning lawyers out there. The questionable estate planning lawyers will simply just, look past all of this and can, transfer millions of dollars for a few $1,000s to do an amendment to a trust or a restatement to a trust or a new will or whatever the case may be. But good estate planning lawyers, they generally will look at this and ask hard questions and want to spend some time. In this case, they'd want to spend some time with Robbie Robertson to make sure that he understands, hey, there's this plan. It sounds good, but do you understand what it means to your children for the next 30 years? Do you understand that they're obligated to help pay for some of this? And as long as that was disclosed to him and he's okay with that and nobody's forcing him to do that, then fine. But if he's not and he can't even understand what the plan is, doesn't understand what the impact is, and really does want his children to end up with his assets when he's dead and gone, well, then there's a problem. And that's where the court system comes in to resolve that dispute.
Yeah, and that's where you do have to be careful with the estate planner you choose, because there are very good estate planning attorneys out there, but there's also not so good ones. And it makes a huge impact on the case. It makes a huge impact on whether or not you're going to see people like us, litigators, when everything goes south, which really kind of brings us to our next topic, which is dealing with difficult attorneys. Because you think about, the people, so nobody likes attorneys, and that includes other attorneys. And so there's plenty of attorneys that we don't like. There's plenty of attorneys we do like and that we respect and that we think are great. But we also, being litigators, we come across people all the time who we just cannot seem to work with. And, what is it, I guess, that makes for a good attorney, especially when you're litigation over a trust and will matter versus a not good attorney? I mean, what are some of the frustrations that we run into, Stewart, when we're handling these litigated cases?
Well, attorneys, probably 80, I'm using some rough numbers here. 80% of attorneys are not very good. Let's just be honest. And I hope we're not in that 80%. I'm not going to sit here and say that I've analyzed myself and I put myself in the 20% of attorneys that are good. I'll let somebody else make that analysis. I'm either in the 80% of just mediocre attorneys to bad attorneys, or I'm a good attorney, but I'll let somebody else make that assessment. But I can make the assessment about the lawyers we go against. And the 80% that I see a problem with are lawyers that are afraid. And the reason they're afraid is because they don't know and they haven't taken the time to know. And they maybe be a little bit lazy. And so when you try to work with them on anything, they always think there's something nefarious out there. So you're just trying to do something normal and customary in a case and hoping to resolve it for the clients involved, your clients and their clients. And they think that you're doing something nefarious. They think you're doing something inappropriate. I'll give you an example. we just recently had to file an ex parte petition in Los Angeles. An ex parte it's a type of emergency petition where something has come up and you need to get the court's attention, and you can't wait for a regularly noticed motion, which could be months out. And so here we have this ex parte we needed to file because we had a deadline, a court-ordered deadline for September 30th that we had to address, and we couldn't address it by September 30th. So we filed this ex parte and asked the court if they could give us a little breathing room so we could respond appropriately to the court's order, which is the right way to handle this. Well, the opposing lawyer didn't get this, and so he thought this was a personal attack on him and an affront to him, and attacked his, who he is as a person, I guess. And we tried to explain it in 3 or 4 emails, and I just finally gave up because he was not going to understand that we're just trying to, hey, we're just getting some breathing room here so that we can respond to the court's order. And we think the request we've made with the court is very reasonable. We think the court's going to agree with us it's reasonable, and we're not attacking you. In fact, you're not even in the analysis, quite frankly. But this person took it very personally. And then, of course, these very venomous emails start coming, at least in my opinion, they were venomous emails. And so it sours what we're trying to do. And we can't explain to the guy that, hey, we're not trying to cause you any heartburn over this. We're trying to do something here. Can you see what we're trying to do? And, he doesn't even want to talk about it. So now he's angry and he wants to lash back out at us. And we're saying, look, we're just trying to do something very simple here. But this is something that happens over and over again. What are your thoughts on that?
Yeah, and I think people have a hard time understanding how to engage in a conflict profession that we're in without making it personal. And you can be conflicting and still be civil. Now, before I get into that, though, there is a comment that I want to touch on that kind of touches on our last topic. So what if the estate planner, we were talking about estate planners, is the successor trustee?
That's what Tanaka has asked. Tanaka is listening in. Thank you for being here. And she asked that question.
And that's a great question, because in California, if the person who drafted the trust puts themselves in as trustee, you can get them removed. And so under our probate code, that's not acceptable. There are exceptions. So if you have a certificate of independent review, or if the attorney is acting as a co-trustee with somebody else. But if the estate planner put themselves in as a trustee, that is a basis upon which you can get that trustee removed, because our laws under the California probate code don't let estate planners benefit themselves by putting themselves in as trustees or making gifts to themselves or making gifts to their family members. All of that is off limits under the California probate code.
So this all came, Keith, from a lawyer in Orange County many years ago, before you and I started practicing law. And there was a what am I trying to say? A leisure world. It's a
yes. It was a retirement community.
It's a retirement community. That's what I'm looking for. It's a retirement community. And this lawyer, boy, he had all of his clients that were in this retirement community. Of course, retirement community, these are older people. And he would go around doing all their estate plans. Well, when he came across people that didn't have children or anybody that would report anything suspicious, he not only put himself in as the successor trustee, he put himself in as the ultimate beneficiary. Right. And so he did it for a long time, and nobody caught on to it. And then when we finally caught on to it, then the legislature got involved and said, wait a minute, lawyers are in such a close fiduciary relationship with these people and can get people to do all kinds of things. So we're just going to say, to help the lawyers not be tempted, which lawyers shouldn't be tempted in this regard, but to help them not be tempted, we're just going to exclude lawyers that draft the plans from getting, number one, any beneficial interest under the estate plan. But we don't want them to be trustee of the plan as well.
Yeah, exactly. And there's an exception too if you're a family member. So I could draft a trust from my mom, and I could put a gift in if she wanted to myself. But those are very narrow exceptions. By and large, yeah, attorneys are not allowed to do that. Going back to what we were talking about in terms of the conflict, I think it's a rare individual who can engage in, the conflict profession that we're in and still be civil. But that it can be done, and that's obviously the more appropriate way to do it. And that's why you hire lawyers. The reason you hire lawyers is to take the personal emotion out of it. And so you as a party, you're not going to be a good lawyer for yourself. And Stewart and I have found this out the hard way. when we unfortunately have been, parties to a litigation, which, doesn't happen that often, but it has happened to us, once or twice. And, we think as lawyers that we're going to make the best decision for ourselves, and we don't. And we've proven that to ourselves by making decisions in cases we're involved in, and later finding out that we made a bad decision and we should have just listened to our lawyer. And so that's the problem, is that trying to be your own lawyer and in a heavily litigated case that is filled with emotion, which most of these trust and will cases are, you're not going to be a good lawyer for yourself. So the better approach obviously is to hire a lawyer, but then that lawyer shouldn't be taking things personally. This isn't personal. This is a profession. It's the practice of law. We're doing things based on a set of rules that is in the CCP, the California Code of Civil Procedure. And those are the rules that we're following. And yet I think this idea of, I have to be a good lawyer, I have to fight you on every single front, it doesn't make any sense. And I'll tell you, the attorneys that I've come across that I'm the most impressed by, or maybe even intimidated by, are the ones that are the most civil, because those people know what the heck they're doing. When you come across an attorney who's just blustery and, fighting for no reason and yelling for no reason, you're like, well, that's kind of bush league. That's somebody who really doesn't know what they're doing. And because they don't have command of what they're doing, instead they just kind of, engage in theatrics, which is it's not impressive. It's not intimidating. It means nothing. It's just it's like a dog barking. Those little yappy dogs that bark, but they couldn't possibly bite you. I mean, that's what it ends up being. It's just not that impressive. Which kind of makes me think about the comments that you've made before, Stewart, about, you have to know when to be a diplomat and when to be a fighter. There's times when you have to fight. There's certain issues you have to fight over. And then there's other times when you have to be a diplomat, and you have to know the difference.
Yeah, you do. And Keith, I'm going to bore you with my soliloquy I gave you the other day. And that is, I've been doing some studying on Alexander the Great, and I ended up doing a study on his father, Philip II. And in my mind, Philip II is much more impressive than Alexander the Great, but yet Alexander gets all the glory in the history books. But Philip II was an interesting dude. He had a big army. He was merciless at times, and other times he was merciful. But essentially what he would do, his MO was, if he wanted to take over a town or a city or a village, and it had a wall around it and a moat or whatever it might be, he would show up with his army outside the gates of that city. And he would say, today I am here as a diplomat. Today I am here as a friend. Today I am here to make you an offer that you can't refuse. And I have my lawyer standing here, and I have my notary with my signature ring, my king ring. I'm going to put it in wax, and I'm going to stamp it. I won't harm anybody. I won't hurt anybody in your town. But I just want you to say that I'm the leader, and you're going to let me lead. And I'll tell you why I'm a good leader, is because I'm in charge of everything anyway. I have this whole area, and you guys can trust me. I'll make your economy good. All these good things. And he goes, but that's today, and I'm a diplomat today. If you refuse, then tomorrow I'm no longer a diplomat, but a warrior, and I will kill everybody. And he would do that. To the 2% of people that would not listen to him when he made this speech and accept his very gracious offer, and they would stand up and fight, they usually got the worst end of it. So let's bring that back to being a lawyer. And one of the finest lawyers I know, I almost don't want to say his name because I really admire him and like him very much. I probably won't say his name, but he's a lawyer that's had a huge impact on my life, and it's because I actually litigated against him years ago, and we were in trial in San Diego in front of a fantastic judge there, and this guy just mopped the floor with me. We ended up settling the case about 3 weeks into trial, which we were happy about. But he was so inspiring to me. I actually enjoyed listening to him cross-examine witnesses and experts, and how his whole approach to the case. And he was always a gentleman to me. He shook my hand, looked me in the eye, was kind. When court wasn't in session, he'd ask about my family and ask about where I came from. I mean, he just was a genuinely really neat individual. And I thought, that's the kind of lawyer I want to be. I want to be a lawyer where I can be a diplomat when it's called for. And I don't want to demonize the other side just so I can fight against them. I am going to fight against them. I am going to push my client's interests and agenda forward, but I can do it in a manner where I'm not just an asshole, where I'm not just, being difficult to be difficult, show that I can pound my chest and yell and scream, and I can cause people to cry in depositions. I mean, that's not really what I want to be. I want to be a lawyer that knows what I'm doing, advocating for my client's position, pushing that position forward. And there's times where diplomacy is called upon. And then there's times where you got to pull your sword out and be a warrior, but you still can do it in a way that's ethical, in a way that the judges like you. I mean, judges do not like lawyers getting up and arguing like school children or a toy in a sandbox. It literally drives them insane. But if you're making a argument from principle, you're making an argument based on the law, and you're doing it in a voice that's not snarky, and you're not saying horrible things about the other side, but you're just making your case, you can be devastating as a lawyer, because judges listen to that. Judges want to know, what do you want from me? What authority do you have? And if you're sitting there and you're the adult in the room and you don't respond to the snide remarks, you don't respond to the people saying, things, snarky things, and trying to get you, to bait you into fighting over the toy in the sandbox, just ignore that stuff and focus on the case before you. So there's a time for diplomacy, there's a time for fighting, but even when you're fighting, you can do it in a manner that other people go, that's a decent human being, and that's a good lawyer, and they're fighting hard for the client, but yet I like that person as an individual, even though I'm opposing them at this time.
Yeah, I think people don't realize or think about the fact that law is a people business. I mean, this is all a people business, and people think that the law is black and white, and it's not, because it's interpreted by people, right? Either a judge is going to decide the case, a jury, or it's going to go to mediation. There'll be a mediating judge. The parties have to come together. And so we have to work with our clients. We have to work with opposing attorneys. We have to work with witnesses, expert witnesses. You have to work with the judge. I mean, it's constantly just a matter of working with people. And if you're going to go out and just be the biggest jerk in the world to everybody you encounter, you're not going to be able to work very well in a people business that way. People, even people who are supposed to be friendly, like friendly witnesses. And we've seen this. We've seen attorneys ostracize friendly witnesses just because they're jerks, versus bringing them on board so that you can get what you need out of them and make them feel good and safe with what you're asking them to testify to. It's a huge difference. And that's I think where people don't really think about it. It's like, I just want an attorney who's a bulldog. You don't. I mean, you want an attorney who's going to stand up and fight for the right things at the right time, but you also want an attorney who's going to be able to build consensus and bring people together, because otherwise your case is going to go on for 10 years and you're never going to get to a resolution. And the one thing that clients should want more than anything is a result. Clients should want a result out of their case, and that takes a lot of different skill sets. And another important skill set is communication. I mean, lawyers are so bad at communicating, I think, a lot of times, even with their own clients. And we see that all the time, where, clients will come to us from some other firm and they just haven't been communicated with. And so that's something that, we really value and find very important, is talking to clients, keeping them up to speed. Some clients want more information than others. Not everybody wants to know everything that's going on, but at least meeting that client's need for communication is so important. And that's a skill that, I've had to learn over time, just being able to communicate with the client to meet that client's need for communication. But man, does it make a huge difference to the client.
Well, and I think the state bar would agree with you. There's lots of things the state bar gets involved with, but there's two big ticket items that lawyers, I think, make mistakes on. And one of those is communication with their clients. I think you were talking about communication in a larger sense, but certainly communication with your clients is one. And that is not responding to emails or text messages or phone calls just because you're dreading, talking to the client. And by the way, we all have those moments, but you have to call your client. You have to talk to them. You have to respond to them. The other area the state bar gets very interested in is when money goes missing or gets misallocated. And so if lawyers just stay clear of those two areas, don't be a Tom Girardi. Don't steal your client's money. Don't be a Michael Avenatti. Don't steal your client's money. Don't misappropriate your client's funds, and actually communicate with your client. If you just did those two things, chances are you're gonna be fine with the state bar on anything else that comes up that I can think of. Now, maybe there's something I'm not thinking of, but those are the two areas. But in response to your thoughts on communication, it's not just communicating with your clients, which is a big ticket item. It's communicating with the court, with the judge. It's communicating with the opposing counsel. And again, there's a way to do that. And you've helped me through the years, Keith, dramatically. I used to file these big, long motions, and you would always say, what are you trying to say? What's the gist of what you're trying to do? And I'd tell you, and you're like, well, then put that. And we would take a 20-page motion and turn it into a 3-page motion. And there's nothing better than telling the court, this is a straightforward matter. Okay, the court should do the following, colon, boom, boom, boom. And there, you've given it to the court, right? And there's, people, it's not this simple, but people say, you tell them what you're going to tell them, and then you tell them what you told them. There's a little bit of truth to that, but you want to be a good communicator. And to be a good communicator, it's not easy. And that's why lawyers should get paid the big bucks if they're going to be good communicators, because getting that down in writing, what was the author, 20th century author, was it Mark Twain, that said he sent a letter to somebody and said, sorry, the letter's so long, I didn't have more time to write it. In other words, I didn't have time to edit it, condense it, and bring it down. And that's really that kind of communication with the court. You need to have good communication with the court. And when the court starts to trust you and trust your communication, you don't overstate cases. You don't overstate statutes. The cases you do point to and the statutes you do point to apply to the matter that you're talking about. And that takes time to build that trust with the court, especially in California when we appear before so many judges. But they do pick up on this and they go, oh, that's from Keith Davidson. I can trust that he's being honest. At least he's attempting to be honest in the way that he's quoting that case and applying it to the facts of this case.
Yeah. And judges hate when lawyers don't talk. I mean, they just absolutely hate it. And, I don't blame them. I mean, if I was a judge, I would hate that too. It's like, you got to talk, you got to move this thing forward. So it's really, it's just shocking to me that people are so bad, attorneys in particular, are so bad at communicating. So let's see. I wanted to we looked up to see if there was any updates on the Vanderpump Rules case. I didn't find any new news articles. We are waiting. That case actually went up on appeal because of the anti-SLAPP, which we talked about before. And we're hopefully going to get the appellate briefs once they're filed. But it can take, 6-7 months to get those?
Yeah, and then the parties can always ask for extensions. And there's usually one party that wants to delay everything. So they ask for 2, 3, 4 extensions to get their brief in. So yeah, it could take some time. But when those come up, I'm really interested to look at those and dissect them and talk about them. And, these kind of cases where there's publicity involved, this is where courts can really make a difference in their rulings. And they can even make some law that'll help clarify the law going forward for the rest of us on how these anti-SLAPP motions are going to be handled.
Yeah. So we do want to encourage everybody, if you have any questions for us, always feel free to leave them in the comments. We're here and happy to answer questions on anything that we discuss, or even things that we don't discuss. And you can always do that. Or if you have a topic you think would be good for us to discuss, you can leave that in the comments as well. We're always happy to get topic ideas. We are waiting for the next phase of the whole Girardi saga to hit the courts, as well as Vanderpump. And then of course there's been this big blow up with Diddy in the news. So, which I've barely scratched the surface of, but apparently that's a mess.
Apparently at his parties, you have to have IVs to survive. So that's, those are some crazy parties.
Yeah, I would think so too. So that could be another upcoming case that, we'll have to keep our eye on and just, see how that unravels. And I know they had that one video out of it was from some years ago, like 8 years ago, in the hotel hallway, where it looked like there was some physical abuse there. So
somebody got kicked
going on. Yeah, somebody got kicked.
Somebody got thrown to the ground and kicked, but yeah.
Yeah. So please be sure to subscribe to our YouTube channel, leave us a like, and always feel free to leave comments. Even if you're not able to tune in for our live shows, if you put comments onto our YouTube video or on this video, we always go back and look at them for our next show so we can be sure to answer all of your questions. So I think that's all we have time for this week, Stewart, and we will be back again next week to pick up and let everybody ask 2 lawyers whatever it is they want to ask.
Awesome. Thanks, Keith.
All right. Nice seeing everybody. Have a great day.